to Legally Speaking with me, Tarun Nangia. We now embark on the part 2 of our discussion on the appointment of arbitrator. And again, introducing you to the topic. These days, no business discussion ends without a very important discussion on the arbitration clause, because everybody is conscious of the fact that in a business, disputes are normal. It happens. But how quickly you solve the dispute is essential for a long-term relationship. This is also true in marriages amidst humans, that you may fight with your wife, but how sooner you solve that fight ensures a healthy marriage. It's nothing more complicated, though the legalese words are a bit strong, but otherwise it's the same. So we will first start with Justice Lokur. Sir, was I right in my description that this is more like marriage? The quicker you solve your fight, the stronger you go in terms of your marriage.
Well, I'm not sure if you can, have dispute resolution and, marriages on the same platform. No, I don't think so. But, dispute resolution is something which I think we have to, amicable dispute resolution is something that we have to encourage at all levels, right? And I think an effort has to be made, not only by lawyers, but by judges, by institutions, to ensure that there is amicable settlement of disputes. Let me give you, an example from my experience in mediation. Now, we have court-annexed mediation in Delhi, particularly in the district courts and the High Court also, and we have court-annexed mediation in some other parts of the country. People are wanting to settle their disputes, right? Whether it is through arbitration or whether it is through mediation, whatever manner, but they want to settle their disputes and they want to settle it amicably and quickly, right? Expense is also one of the aspects of it. So really, if we want to encourage arbitration, we have to look at all these, variable factors. Is it expensive? Is it time consuming? Are we going to get, the best that we are looking for? So these things have to be taken into consideration, and only then I think, whether it's industry or whether it's, individuals, or whether it's, outside, parties from different foreign countries, it's only then that they will find it worthwhile coming to India for arbitration. So we have to get our act together, and it's not difficult. I can tell you from my experience in, doing mediation and being chairperson of the Mediation and Conciliation Project Committee of the Supreme Court. It's not difficult at all.
So you're indicating that India not only will be a destination for Indians, but can be a destination for South Asian countries to arbitrate?
Yes, absolutely. Absolutely.
And in your view, how many years should it take if we start to do it now?
It can't take long. There are a few things, that you have to put in place. One is a standard operating procedure, which I had adverted to in the first part of the program, where, there's no procedure that is laid down. Why can't we have a standard operating procedure so that everybody knows what's happening? Why can't we have institutional arbitration rather than ad hoc arbitration? What's wrong with institutional arbitration? So you have very successful institutional arbitrations going on, SEAC, for example, ICC, right? Why are they succeeding? They're succeeding because they've been able to get their act together. Why can't we do it? Rather than have LCI going out of India. So these are not, difficult issues. Training of arbitrators. Lord Marston had mentioned many years ago. I remember I was among the audience when he gave a lecture. Training is so important for arbitrators. I mean, just because I'm a judge, it doesn't mean I'm going to be a good arbitrator. There's a lot of training that's involved in that. And just because you're a lawyer, it doesn't mean you're going to be a good arbitrator. You have to be trained for the job. So these are, a lot of things that we need to look at. If you ask me for a time frame, I would say that definitely not more than 2 years. Definitely not more than 2 years.
2 years of consistent And infrastructure also.
Yeah, infrastructure. Well, you have fairly good infrastructure, as far as I know, in Delhi. But of course, there is room for improvement, And yeah, it can be done. Not a difficult job at all.
So India can emerge. I mean, we should take heart in the fact that it's not that we cannot. We can do it.
We can, and easily.
So that is a good note to continue this discussion. Senior Advocate A.V. Vishwanathan, now, is it giving dissenting award a normal practice in India, or do you see it rarely happening?
I have seen dissenting awards. In fact, I have seen a dissenting award by very eminent judges who have turned as extremely sought after arbitrators. I saw in a foreign award a dissent by an Indian judge, which was far more appealing than the majority award. So it all depends on the reasons that go behind the award. The marshalling of the evidence, the application of the law. But if it is dissent for the sake of dissent, of some loyalty, to the party which nominated you, then that, becomes suspect. But while one can't take extreme positions on this, to dissent today is recognized as part of a free speech for a judge. Justice Nariman in his beautiful book, Discordant Notes, I'm halfway through it, I'm just not able to put it down, says that it even touches on free speech. And, it depends on the reasons that go behind it. So dissents are welcome in a multi-member panel. It's bound to happen. I don't think a right-minded, a legal professional could see it as, some kind of a stigma to the board. It is a welcome measure. By and large, in courts also, unanimity is attempted, but not at the cost of, compromising your conviction in the matter. So that applies to arbitrations also. So I just see dissent in the same light as a judge in a multi-member panel would dissent.
Okay. Am I audible?
Yes, just a slight echo, but otherwise you can hear it.
So Shashank, I want to know from you. Now there is this talk about appointment of foreign arbitrators. Now the dispute is in India. It's happening in Delhi. The dispute involves Indian parties. Why do we have foreign arbitrators? Are they even necessary?
See, the first question that you had put to Justice Lokur was, what is the qualification of an arbitrator? Who can be an arbitrator? Now, if you look at the Act, there is no requirement for the arbitrator to be an Indian citizen either. So an arbitrator can be anybody from any nationality, right? And foreign arbitrators arbitrate in disputes, usually in disputes involving parties which will have one Indian party and one foreign party. And although I've seen in a domestic dispute also where there were NRIs involved, the entire tribunal consisting of foreign arbitrators, but usually you would see that happen only when there are parties that are international parties, and it's an international commercial arbitration or an investment treaty arbitration where foreign arbitrators are sought after, or at least they become the chair. That happens because you are mostly using an institution to come into play. If there's a foreign institution such as ICC, CIAC, or even an Indian institution of repute where there are parties from multiple jurisdictions, it is usually the practice to choose an arbitrator from a neutral nationality. And that's also, in fact, envisaged under the Arbitration and Conciliation Act, that in case of an international commercial arbitration, Supreme Court will at least make an endeavor to appoint the presiding arbitrator or the arbitrator from a neutral nationality. That is just to balance the equities so that neither of the party feels that, okay, we may be in your home turf, but at least the gentleman who's listening to the dispute comes from a neutral nationality. So I don't see a problem appointing foreign arbitrators, but on the same hand, there should not be some sort of an addiction or some sort of extra charisma that is attached to foreign arbitrators. One might not think that just because bringing in a foreign arbitrator should change the course of how the arbitration is to be conducted. As Justice Lokur pointed out previously, all Indian arbitrators, most of them who do bigger disputes, now follow stringent processes. So those times are gone.
Shashank, if fly-in and fly-out arbitration is possible, for example, if a foreign arbitrator can come here, if a Queen's Counsel can fly in from UK and appear before the arbitration panel here, then why are foreign parties, when they do business with Indians, insisting on a seat of arbitration to be outside India? Can we do something to change that?
So that's actually a very, very different point altogether. When you talk about India as a seat and Indian parties arbitrating in India, it's a very different question, because seat is something where parties want to take into account the level of judicial interference. Now, Indian courts, unfortunately, at least 7-8 years ago, used to be very, very interfering. It was very easy to interfere with an award. It was very easy to get an interim relief. It was very easy to get a stay on the award. And execution, I mean, all of that has been resolved. However, execution still remains a very big issue, which takes forever. In spite of judgments like Vijay Karya by Justice Nariman and other Supreme Court judgments where some sort of a deterrent has been, the courts have tried to create some. But enforcement and execution still takes several years. And India, although in the last 10 years, I would say, has been progressing really well, all stakeholders have taken steps: legislature, practitioners, arbitrators, as well as courts. So we have created a new niche in the world arbitration market. So it would not be, it's not far away from when parties would actually be open to putting India as the primary seat of arbitration. As Justice Lokur said, 2 years, maybe 5 years for the seat. But as far as infrastructure and everything else is concerned, I think a couple of years is sufficient.
Just to supplement, Tarun, if I can add a bit to what Session said. Just as our program as a part 2, the Arbitration Act as a part 2, and foreign seated arbitration, an award emanating out of it, enforcement is much easier. All that the award holder needs to do is apply for a recognition, and the onus is on the judgment debtor to come within very narrow gateways which are prescribed in 48. And invariably, they don't make out a case and the award gets recognized and capable of enforcement, which means all that remains is an execution. So that is the reason why they prefer. So actually the problem is in the post-award stage to tighten, they have attempted to tighten it both in the 2015 amendment and in the 19 amendments to tighten the mechanism for, the setting aside proceedings and the resultant pendency which emanate out of it.
I'll ask Justice Nadan Lokur, sir, if as per the Arbitration Act, the court only has to see whether there is an existence of a valid arbitration clause, then do we need the High Court judge to put their precious judicial time on this, or some administrative committee of the court can also take over this job?
Well, it's an interesting question, actually. A lot depends upon the interpretation of a contractual provision or a statute. Now, one of the basic things that we are told in a contract is that there is a contract that the parties are ad idem. Now, if they're ad idem, there can never be a dispute, right? Because everybody knows what is supposed to be done, and the other party also knows what is supposed to be done. But there are, nuances even in arbitration clauses as there are in contracts. And for that reason, the question of interpretation arises. Theoretically, it can be done by a person who is legally trained, like a lawyer, for example. All right. So in that sort of a situation, it need not go to a judge for interpretation. I'm in favor of, two-tier kind of settlements, in the sense that the example that you have given, get the opinion of a lawyer, right? Both the parties might accept it. If they don't, one of them is dissatisfied, okay, then you go to a high court judge, right? Go to the high court and get a resolution. So I'm really in favor of this two-tier thing only for the reason that it brings about some kind of a certainty. And it brings about that kind of a certainty quickly. And the second thing is, if this thing is institutionalized and you have a repository of decisions, okay, because many of them are not even reported. So you have a repository that if the arbitration clause is worded in this particular manner, then this is what it means, right? And I think over a period of time, these kind of disputes will vanish. So there has to be a lot of thinking, that has to go behind all this. I mean, just making an amendment is no good.
Okay. That point very well taken, sir. I'll go to KB Vishwanathan, sir. Do you think the accountability of arbitrators has increased over the past few years in India? Because there are disclosures, there are stringent timelines. So the accountability by and large has improved, and that is why businesses are wanting to arbitrate. Do you think we have achieved what we had to?
I think so. The conscientious ones were always accountable. They didn't require a 29A for time limits. But sometimes arbitrations tended to linger on. There was no daytime arbitrations. It was more like evening arbitrations, weekend arbitrations. So today there is a claim, and I agree with Justice Lokur, that we need an arbitration bar and it should function during the normal working hours. And if a lawyer practicing on the appellate side is not able to take it up, so be it. Let an arbitration bar develop. It will be in the interest of the profession. It will be in the interest of the subject matter of the arbitration also. Certainly with the incorporation of time limits, the disclosure norms, accountability has increased so as to infuse confidence in arbitration. Just imagine, earlier when it was open-ended, and if an award comes when it should have come in a year or two after 7 years, the losing party pays interest. He pays interest for the additional period. And that is not his fault. If he had been told at the end of the second year that this is what you need to pay, his liability would have been much less. So today with timelines, certainly, accountability has increased. The new act has really heralded a new era. But I must tell you that even earlier, the conscientious arbitrators were always accountable because they were first to be accountable to themselves. But this has certainly given it a statutory flavor, and it has brought even the aberrations online.
Do you feel courts are fast enough to decide Section 11 petitions, or they linger on? I mean, are courts, in a sense, quickly responsive, or do you think we need to do better on this?
So it depends who you are asking. If you're asking a lawyer in Delhi or in Bombay, their answer would be very different from if you're asking a lawyer in Chandigarh or maybe in Jabalpur. I mean, as far as Delhi courts are concerned, including Supreme Court, I think it's on a lightning speed that appointments are being done. I've seen many occasions where the courts on the first date itself, if the other party is present, just ask the other side if they have any objection. If there is none, the arbitrator is appointed even without issuing of a notice. I mean, there are many cases where the other side really does not have any valid objection, and the courts are open to hear the objection on the very first date itself and tell them that, this will not fly. So if they insist on a reply, I'm sure the time is given. But that's only Delhi, Bombay, and subject to corrections. I have seen some other high courts have taken 2 to 3 years just in appointing an arbitrator. I without mincing words, Chandigarh High Court, for that matter, only hears Section 11s, which are for contracts or claims more than 5 crores on Fridays, that too after normal working matters are over. That is in the afternoon, only half a session is devoted by the erstwhile or the current Chief Justice, whoever. I mean, that's a trend that's been going on for hearing Section 11. the first date after that notice is issued, the next date will come in 8 months or 7 months. I mean, that's not how Section 11 should be disposed of. It is going to take 2 years just to get an arbitrator. That's not really the objective of all these amendments. That's really not the objective of putting inculcating the best practices that we are trying to. So I think the high courts must have a consistent way or a standard operating procedure, as Justice Lokur pointed out, for conducting of arbitration, as well as for Section 11 and their disposal, because that's where it all begins. So if an appointment will take over a year and a half, parties tend to lose a lot. So that's my experience. So I think it's different in different high courts, and it shouldn't be. Should be as fast as it gets.
Point well taken. I'll go to Justice Lokur, sir. This is going to be the topic of my next show in a month or two. And my last question to you today also. If you could share with me 3 or 4 things that if we could do, India could become a center where there is a lot of fly-in, arbitration. There are NLS colleges in India. A lot of them wish to go out and enter the field of arbitration, that is, leave India and do it. What can we do to make India itself that destination that nobody aspires to go abroad? We get it all done here. In your view, what should we do at the earliest? What are the early fruits that we can, in a sense, the low-hanging fruits that we should aspire to achieve?
Yes. One of them, of course, is what Shashank had adverted to, namely the time that is taken for the appointment of an arbitrator under Section 11. I can tell you that when I was there in Guwahati and when I was there in Hyderabad, there were a large number of petitions that were pending under Section 11. Okay. So anyway, to the best of my ability, I tried to clear them up, but they were pending for months together and in some cases for a couple of years. The impact of that is that because arbitration is not given any importance, the lawyers are not equipped to deal with arbitration matters, nor are judges, equipped to deal with arbitration matters. So, this delay has a huge impact, not only on the system, but also on the arbitral process. So that's one thing that we have to take care of, that expeditious disposal of issues that are pending, right? Whether it's on the question of appointment of an arbitrator or Section 34 or Section 37, whatever. Do it quickly, okay? So the moment, there is expeditious justice, I think a lot of issues will get cleared up. That's number one. Number two, I had mentioned to you that we must have some kind of a standard operating procedure, not only for the arbitrators, but also for the lawyers, right? I mean, you can't say that, listen, I'm going to, examine witnesses when it's not necessary. Why should you examine witnesses? And you ask standard questions. What are your educational qualifications? What does this document say? What does that document say? So we need to have standard operating procedures for arbitrators and for lawyers. Third, we must encourage institutional arbitration. That brings about a huge stability. Ad hoc by itself means ad hoc, right? Where is the stability in that? So we need to have institutional arbitration and we need to encourage it. Fourth, training to be given to arbitrators, training to be given to lawyers. Writing an award is different from writing a judgment, right? So presentation of a case in an arbitration matter is different from presentation of a case in a court. I mean, the lawyer is sitting right in front of me, right here. He's not going to start shouting at me and, standing up and arguing and so on. The manner of presentation becomes completely different. So that also has to be taken into account, training. Number 5, we have to learn from history in the sense that we've gone wrong in some places. I can tell you in the late 1970s, early 1980s, there was a lot of litigation against the Delhi Development Authority, and the Chief Justice Delhi High Court said that, let's have an arbitrator from the Delhi Development Authority deciding disputes. What was missed by the learned Chief Justice at that time was that, the awards had to be given under the 1940 Act. Reasons were not required. Huge amount of corruption, right? Arbitration was compulsory, huge amount of corruption. And ultimately, within about a year or so, this policy was scrapped. So when you talked about unilateral appointment of arbitrators, there's a lot to learn from history. I'm talking about the 70s and 80s. And in 2017, 18, we're still talking about the same thing. So there are so many, things that need to be looked at historically, from which we can learn lessons and improve. Like I said, and I'm reiterating it, even though Shashank may not agree with me on the timeline, 2 years is more than enough. 1 year possible, 2 years more than enough. Not 5 years, Shashank.
So the beauty of today is that, sir, thank you so much for sharing all these insights. We will take up this issue in detail in a month's time of what are the actionable, because the governments of the day also want quicker dispute resolution. In fact, in my interaction with various bureaucrats, they tell me that if this dispute resolution becomes faster, pulling in money into this country from abroad will become easier. And they say it in all fairness, money will come in hordes if we can assure them that within a year, in 6 months or 7 months, disputes can be resolved. And we'll do one more show 2 years hence to see where have we reached after what we discussed in the October of 2021. I think it will be the October of 23 to see where we have achieved what we in a sense had in mind. And I think all well-meaning Indians in the field of law will have this in mind, that why not India, if we can be a leader in the auto component sector and the automobile manufacturing in the world, why can't we be a leader in arbitration? You've got such great colleges, such great talent, and such great leaders at the bar who can help us do this, and in the field of arbitration. I would like to thank Justice Madhun Lokur for sparing this time at a very short notice and joining me today on Legally Speaking. Senior Advocate K.V. Vishwanathan, thank you so much for joining me at a short notice. Shashankar, I would like to thank you for joining me on the show and also contributing meaningfully to the field of arbitration. May you continue to do better, and in a sense, we could take up more constructive issues in this field. Thank you so much for joining us, and thank you, viewers. Without you, we wouldn't be able to do this week after week. And also, in a way, your feedback on the issue of arbitration with what businesses want has helped up take up this show to this level. Because in the end, as we all say, it is because people do business that there is a lot of work on each end in disputes. Because if there is no business, there are no disputes. But if there is no rule of law, then nobody can do business. Thank you so much.
Thank you.